Welcome to the video lecture for Chapter 7. So Chapter 7 serves as an overview of both constitutional searches and seizures, the Fourth Amendment, and then there is a specific chapter for each searches and seizures. So we'll spend 3 weeks working through the Fourth Amendment, in part because the Fourth Amendment is just incredibly vital to the functioning of our entire criminal justice system. The Fourth Amendment is rooted in the principle that government authority must be limited, but they do need some authority to conduct searches and seizures. So only unreasonable searches and seizures are limited by the Fourth Amendment. So first things first, a search is an examination of a person, place, or vehicle for contraband or evidence of a crime, while a seizure is a taking by law enforcement or other government agent of contraband, evidence of a crime, or a person into custody. Again, the Fourth Amendment is maybe the most vital of the amendments we're going to talk about this semester. That's why we're spending 3 weeks on this content. The cases here, the jurisprudence here details out when and how a government agent can act when they engage with citizens, when they conduct searches and seizures. And remember, super important, there is not an absolute right to be free from government intrusion, only these unreasonable searches and seizures. So one of the most important cases that one of the foundational cases, I guess, not necessarily important, foundational cases of the Fourth Amendment is Wolf v. Colorado, 1949. And the issue here was, if evidence is illegally seized, does it need to be excluded from the criminal trial? And the answer is yes. Government agents are regulated by the Fourth Amendment through the 14th Amendment, and evidence that is obtained illegally cannot be used in those criminal trials. Now, the first step in our Fourth Amendment analysis is always, who is our actor? Who conducted the search or seizure? Because private individuals or agencies are not regulated by the Fourth Amendment. Parents searching their teenager's room, parents are not government agents, at least in that capacity, even if they are in a different capacity. Store detectives, they are not government agents. They are not regulated by the Fourth Amendment. And we see this has also been litigated out. UPS employees can open packages that are insured for more than $1,000 without a warrant. Meanwhile, airline employees cannot inspect luggage because they are acting under FAA regulations in a government capacity. A private party could be deemed a government agent if they are acting on behalf of a government agent. So if they agree to go get an item from a house, or a store detective agrees to search somebody on behalf of the police, those are extensions of government authority, and the Fourth Amendment would apply. The Fourth Amendment contains 2 clauses. The first clause is the reasonableness clause. And this part of the amendment states that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. Unreasonable being a very important word for this entire area of law. The warrant clause, meanwhile, states that no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Again, telling us what type of conduct is acceptable. Now, since the 1960s, the court treats these 2 clauses as distinct clauses. They address separate situations, and this has also enabled warrantless searches to be possible. This distinction between the 2 clauses of the Fourth Amendment. Now, when we're talking about these definitions, let's talk about some of the framework and how they are evaluated. Reasonable, some synonyms for reasonable are going to be sensible, rational, and justifiable. Fourth Amendment cases could be evaluated using a bright line approach where one specific rule applies to everything, such as all drug dog sniffs are searches. That could be the rule. It could apply to everyone across the country. That is not the most common way that Fourth Amendment law is handled. And by the way, that was just a made-up example. It's not actually accurate. Case-by-case method is the more common way that we evaluate Fourth Amendment issues in cases. We look at each case based on the totality of the circumstances and determine, was this conduct reasonable or not? Now, when we start thinking about the warrant clause, it's very important to distinguish between probable cause and reasonable suspicion. Reasonable suspicion is a suspicion. Probable cause is stronger than that. It needs to be strong enough to justify a search or an arrest with or without a warrant. And a good way to think about this is, would a reasonable person believe that a crime was committed, has been committed, or is being committed, and this individual committed the offense, is committing the offense, or that contraband or evidence is in a place believed to be? If so, then probable cause has been met. Probable cause must be established before a search or arrest can be made, not after. Facts and evidence obtained after are not used to establish probable cause. Now, if probable cause was a little bit weak, the evidence obtained after can be used to strengthen it, but it cannot be used to go back and establish probable cause. Excuse me. The case versus Aguilar versus Texas, these couple of cases detail how informants work with probable cause. Often, informants are a basis for law enforcement information. And in Aguilar, informants had to meet a two-pronged test. The informants had to have credibility. This was often established by showing that officers had worked with this warrant for X amount of time and had obtained so many arrests using the information. The informant's basis of knowledge had to also be established, and the reliability had to be established. So this was a fairly strict standard for the occasions where officers could obtain a warrant using informant information. In Illinois versus Gates, officers received an anonymous letter that outlined very specific details about the defendant's drug trafficking participation. Police observed and corroborated some of this. And the question was that letter enough for probable cause? And the Supreme Court said yes, and they abandoned the test in Aguilar and replaced it with a totality of the circumstances test. This has made it easier to use informant information to obtain a warrant. So 2 clauses here, just a short recap. 2 clauses: reasonableness clause, warrant clause. Reasonableness, we assess totality of the circumstances. Warrants have to be supported by probable cause, and warrantless searches also have to be supported by probable cause. Now, search and arrest warrants that are issued from probable cause. Government agents, once they have enough information, they go before a judge or magistrate and they swear an oath about who and what they're looking for and where they think it can be found. Remember, it has to particularly describe the person or things to be seized or the place to be searched. Judges then look and determine if probable cause exists based on the totality of the circumstances. Not all judges will sign every warrant. Sometimes judges will say you need to come back with additional information. You're close, but you don't have enough here for probable cause. And judges today grant warrants over the phone and through other mediums, which is important given kind of the time-sensitive nature of at least some of police work. Now, when a warrant is is executed, officers generally have to knock and announce their presence unless they request a no-knock warrant. The reason that officers are required to knock and announce unless they get permission from the judge to not do so is to prevent occupants from responding with force. Occupant could think that they are being robbed, that they might be robbed, that they might be a burglary is going on, and they could respond with force. Meanwhile, those officers are legally allowed to be there, and so this is designed to reduce conflict in force. United States versus Banks in 2003. Banks was in the shower when officers executed the warrant, so he wasn't able to respond. Officers waited 15 to 20 seconds after announcing before entering, and the question was that a reasonable amount of time to wait? And the Supreme Court said yes, that was reasonable. Somebody could destroy drugs within 15 to 20 seconds, and so that was an acceptable timeline to enter. Now your book in figure 7.3 has this continuum of context graphic that displays kind of the variety of ways that police and public can interact with each other and how the Fourth Amendment interacts there. I think it's really important to kind of work through as future criminal justice professionals. Now, we're going to talk about stop and frisk next. So stops are brief detentions based on specific and articulable facts. Miranda warnings are not required here, and the goal of a stop is to investigate suspicious activity. Articulable facts means that the actions of the suspect can be described in clear, distinct statements. So they can explain why this person was suspicious, why their behavior was suspicious. And then a frisk can be conducted, which is a limited pat down for weapons for the protection of government agent and others in the area. The law of stop and frisk is rooted in Terry v. Ohio, 1968. Terry and two other men were observed by a plainclothes officer in what the officer believed to be a casing job in a stick-up. Officer frisked the three men and found weapons on two of the three. Terry and the other men, they challenged this as an invasion of their Fourth Amendment rights, and the Supreme Court found that no, this did not violate the Fourth Amendment rights of these men because the officer acted on more than a hunch, and a reasonably prudent man would have been warranted in believing that Terry was armed and thus a threat to the officer's safety while he was investigating suspicious behavior. So this articulates the idea that we don't want to necessarily wait until there is probable cause in every circumstance, because one goal of policing is to prevent crime, and ideally we will catch it before it happened here. So that is stop and frisk, which is a really important case. We're going to come back to it again in subsequent videos. Now we're going to talk about the consequences of violating the Fourth Amendment. So an unlawful search or seizure can have two serious consequences. First, the evidence can be excluded from court. Often this type of evidence is vital to establishing proof beyond a reasonable doubt and may mean that the suspect or defendant, well, the defendant at that point, would not be able to be prosecuted and convicted. Officers can also face internal sanctions in the departmental sanctions, as well as civil and criminal liability. This is due to the exclusionary rule. Exclusionary rule was created by judges with the goal of preventing police and government misconduct. So evidence that was seized in violation of someone's constitutional rights cannot be admitted into court. The exclusionary rule and the exclusion of the evidence is the most common means to address constitutional infractions. Exclusionary rule was solidified in 1914, so it has been a part of American law for more than 100 years. Weeks was arrested by an officer in Missouri. Officers entered the house without a warrant and took possession of papers and articles. These were later turned over to a U.S. Marshal, and the evidence was found not to be admissible because they violated his right against unreasonable search and seizure. This case was then applied to the states in Mapp v. Ohio 1961. Dalry Mapp, her home was searched without a warrant, and the evidence that they seized, pornographic magazines, was used to convict her of the crime of obscenity. And the Supreme Court found that they violated her right against unreasonable search and seizure. So, additionally, the exclusionary rule kind of helps preserve judicial integrity. It deters police misconduct, and it protects your right to have privacy in your home, on your person, in your effects, in your papers. So, a very important part of Fourth Amendment law, as well as the Fifth Amendment law. There are a few exceptions to the exclusionary rule. Law is, designed to evaluate human behavior, and so we need exceptions. Not every situation excluding the evidence is the right or just choice. There are 4 exceptions to the exclusionary rule. One is the inevitable discovery doctrine. This is where officers would discover the evidence anyway through legitimate means. This came from a case where officers were canvassing for a body, and a different officer interrogated a suspect in violation of their Fifth Amendment rights, and the suspect took the officer to the body. Meanwhile, the canvassing teams were less than 2 miles from the body, and the body was in an area marked on their maps. They were going to find it anyway, so the courts deemed the evidence of the body to be admissible. If there's a valid independent source for the evidence, it can be admitted. If there is a harmless error, this is usually used in conjunction with confessions. In good faith, this is often used where officers obtain a search warrant from a magistrate, and upon review, the magistrate should not have issued the warrant because the evidence provided did not meet probable cause. However, those officers did follow constitutional procedures, and therefore the evidence they obtain is admissible. Additionally, officers who violate a suspect's constitutional rights could also face departmental discipline, civil lawsuits, and criminal charges. So, now, one final note. If probable cause exists, officers have the ability to arrest, to search incident to arrest. State laws cannot limit this kind of constitutional parameters. So this is an overview. Again, we're going to come back to seizures and searches in two subsequent chapters over the next couple of video lectures. If you have any questions initially, if any of these concepts are vague or confusing, please reach out because they are kind of vital to moving forward with the rest of the material. Have a great week.